Good afternoon, everyone. I call this hearing to order, and I want to thank everyone for being here. When folks set out on a career path, they know that some of the jobs require certain licenses, educational backgrounds, and fees. Most people agree that certain professions should be subject to standards to protect the public, such as doctors, lawyers, or architects. However, in the United States over the last 60 years, the number of occupations subject to state and local licensure laws have expanded greatly. Today, not only do doctors need a license, but in some states, professionals such as fortune tellers or interior designers require one as well. In light of this, it's not surprising that a recent study found that occupational licensing was the #1 regulatory burden that faces small firms today. Understandably, this growing trend is sparking controversy as entrepreneurs question why certain licenses are needed, particularly if the license or educational requirements seem to have little to do with protecting the public. The balance between individual rights to pursue economic opportunities and states' rights to regulate economic activity within their borders appears to be the tipping point towards more regulation. As entrepreneurs seek out new opportunities, they're finding more roadblocks in the way of earning a living or creating jobs. And often these barriers are erected by licensing boards made up of men and women who are currently in the profession or the potential competitors of those seeking to enter the profession. These hurdles are particularly difficult to clear for those with limited financial means or lower levels of education. As entrepreneurs look for solutions, they're starting to file federal lawsuits alleging that certain occupational licenses violate federal antitrust laws. In my home state of Missouri, we're lucky to be consistently ranked as one of the least burdensome states for occupational licensing. However, in June, hair braiders filed a federal suit against a Missouri law which requires braiders to obtain a cosmetology license. The state cosmetology license requires 1,500 hours of training and 2 exams with all the various costs that are involved. But according to the suit, neither the training nor the test covers hair braiding. And while we want competent and skilled workers in Missouri, I strongly believe in states' rights to protect the welfare of its citizens. This occupational license, which does not seem tailored to the actual profession, appears to be a way to keep new competition out and infringe on an individual's economic liberty. Today, we're fortunate to have Director Gavel from the Federal Trade Commission, who will highlight some of the concerns and inform us of the actions that the FTC is taking as enforcer of the federal antitrust laws to promote competition and reduce unnecessary barriers to work. And now I yield to Ranking Member Velasquez for her opening statement.
Thank you, Mr. Chairman. Occupational licensing is a process by which states compel those involved in a particular profession or industry to meet specific standards, such as training, education, or certain character requirements. The main justification for occupational regulation is to protect the public's health and safety. For example, individuals want to know health practitioners adhere to basic quality standards or that architects have achieved certain training requirements to design structurally sound buildings. However, the rapid growth of licensing requirements across a broad array of job fields has raised questions about the effectiveness of these regulations and potential unintended consequences. In the 1950s, less than 1 in every 20 workers was in an occupation requiring occupational licensing. Today, roughly 30% of Americans work in a field requiring state licensing, creating additional hurdles for entrepreneurs looking to join a new field. New licensing laws are almost always crafted with industry input and enjoy broad immunity from federal oversight. The state's power, however, is not absolute. It falls on the Federal Trade Commission to ensure that occupational licensing standards are advancing the goal of protecting the public and not serving intentionally or inadvertently to limit competition in a manner that runs afoul of antitrust laws. For decades, the FTC has initiated enforcement actions designed to eliminate restrictions on business practices of state licensed professions, including restrictions on new competitors, advertising and solicitation, and even price rigging. As a result of FTC's efforts, robust marketplaces thrive in many professions, preserving consumer choice and keeping price competitive. As always, the key is striking the appropriate balance, preserving occupational licensing systems that serve legitimate consumer protection purposes while preventing licensure from restricting competition and stymieing entrepreneurship. It is my hope that today's discussion will shed light on how the Commission is advancing that goal and how the committee can be helpful on this topic. In that regard, I thank the witness for being here, and I'm certain your testimony will provide and will shed light and valuable insight. With that, Mr. Chairman, I yield back.
Our witness today, as I mentioned, is Andrew Gavel, the Director of Office of Planning, Policy Planning at the Federal Trade Commission. Director Gavel has led this office since September of 2012, and he oversees the office's advocacy efforts to support competition and protect consumers. Prior to this role, Director Gavel taught antitrust at the Howard University School of Law and authored numerous articles on competition policy. Thanks for being here. We appreciate it.
Thank you, Mr. Chairman. Good afternoon. Chairman Graves, Ranking Member Velasquez, members of the committee, thank you for the opportunity to appear before you today. I am Andrew Gavel, the Director of the Office of Policy Planning at the Federal Trade Commission, and I'm pleased to join you to discuss competition perspectives on the licensing and regulation of occupations, trades, and professions. The Commission's testimony describes the FTC's approach to evaluating the potential competitive effects of such regulation and how we use a combination of advocacy and enforcement tools to promote competition among professionals. The FTC and its staff recognize that occupational licensure can offer many important benefits. It can protect consumers from actual health and safety risks and support other valuable public policy goals. However, that does not mean that all licensure is warranted, and most importantly in our experience, it does not mean that the benefits of all of the specific restrictions imposed on occupations are sufficient to justify the harm they can do to competition and mobility in the workforce. We have seen many examples of licensure restrictions that likely impede competition and hamper entry into professional and service markets, yet offer few, if any, significant consumer benefits. In these situations, regulations may lead to higher prices, lower quality services and products, and less convenience for consumers. In the long term, they can cause lasting damage to competition in the competitive process by rendering markets less responsive to consumer demand and by dampening incentives for innovation. Occupational regulation can be especially problematic when regulatory authority is delegated to a nominally independent board comprising members of the very occupation to be regulated. When the proverbial fox is put in charge of the henhouse, board members' financial incentives may lead the board to make regulatory choices that favor incumbents at the expense of competition in the public. This conflict of interest may lead to the adoption and application of licensure restrictions that discourage new entrants, deter potential competition from professionals in related occupations, and suppress innovative forms of service delivery that could challenge the status quo. Such entry and innovation can have substantial consumer benefits. From a competition policy perspective, it is also helpful to appreciate that we view anti-competitive occupational licensing in the broader context of industry regulation that instead of protecting consumers can become protectionist of current industry incumbents. Our economy is evolving rapidly, in part due to emerging technologies that facilitate new products, services, business, and even new business models. When these develop and challenge incumbents in heavily regulated industries, it is not unusual to see regulatory responses spurred on by those very incumbents which erect barriers to new business models and have the effect of slowing or even barring their development, even when consumer demand for new methods is pronounced. The FTC and its staff address these concerns primarily in two ways. First, as part of the FTC's competition advocacy program, where appropriate and feasible, we respond to calls for public comment and invitations from legislators and regulators to identify and analyze specific licensure restrictions that may harm competition without offering significant consumer benefits. In recent years, for example, we have focused on diverse issues, including advertising restrictions, automobile distribution, nursing scope of practice restrictions, accreditation standards, taxicabs and related forms of passenger vehicle transportation, casket sales, and real estate brokerage. Typically, we urge policymakers to integrate competition concerns into their decision-making process. Specifically, that they consider, 1, whether any particular licensure regulations are likely to have a significant and adverse impact on competition, 2, whether the particular restrictions are targeted to address actual risks of harm to consumers, And 3, whether the restrictions are narrowly tailored to minimize any burden on competition. When appropriate, we have also used our enforcement authority to challenge anti-competitive behavior by occupational regulators. The Commission has authorized civil challenges in several instances when faced with delegations of authority to regulated boards comprising self-interested competitors, alleging that each board's actions harmed competition and that state action was insufficient defense to the conduct. As you know, one of these cases, North Carolina State Board of Dental Examiners, is currently pending before the U.S. Supreme Court. The Commission has not studied and has not taken a position on whether there is excessive licensing of occupations, trades, or professions as a general matter. As I have described, however, it has demonstrated a long-standing commitment to tracking and identifying regulatory restrictions that unduly restrict competition in specific trades, occupations, and professions, and has taken enforcement action when appropriate to stop self-interested regulatory boards from abusing their authority to eliminate competition. I am, of course, happy now to respond to any questions you may have. Please note, however, that as is indicated in the written statement of the Commission, although the prepared statement presents the views of the Federal Trade Commission, my oral testimony and responses to questions reflect my views and do not necessarily reflect the views of the Commission or any particular Commissioner. Thank you.
Mr. Hanna.
How do you navigate that process intellectually? I mean, where do you kind of generally set the bar for what needs to be regulated and what shouldn't be? And isn't that very subjective, so that you said you're not particularly proactive about limiting? Does that mean, what does that mean?
It means, in short, that as a practical matter, we have not found ourselves to be very successful when not invited to the party. When state regulators and legislators are considering legislation, we have found over time that we can be most effective in encouraging them to consider competition when we're invited to do so, or when they have indicated a willingness to accept comments, as through public comment periods.
You find that they're relatively willing to listen?
We do, especially when we have those public comment periods and when we're invited. Our recent experience shows that around 3/4 of the time we find that we are at least partially successful in influencing the awareness of the competition concerns that typically are the concerns that we would focus on and explain.
Like what?
So this goes back to the first part of your question, what is it that we are urging and what is our analysis? We are competition specialists. We are economists and lawyers working together. Many people in our office have decades of experience in particular industries, healthcare industry, intellectual property issues, and typically what we would bring to bear on a question of regulation is an understanding of how to evaluate the likely competitive impacts of a particular restriction.
So is it your opinion that regulation, I mean, there are people out there who never saw a thing they didn't want to regulate, and there are other people who believe that free enterprise somehow creates perfect outcomes. I think both are probably misguided. But in general, can you? There are businesses that clearly need licenses and need to be regulated, and those that don't. How do you separate the two? And how do you measure the value that's created through kind of letting the market do it on its own? Because frankly, customers are ultimately the best deciders of the value they receive, and that's part of the process.
Mm-hmm. I would completely agree, Congressman, and I think that one of the things we look for is regulations that interfere with that process. The market is going to work best when you see a free interchange between supply and demand, between the suppliers of services or products and consumers. A recent example, to make it more concrete, we filed comments in Missouri and New Jersey in connection with the practices of auto distribution. 2/3 of the states prohibit manufacturers from selling directly to consumers. We commented that in both instances, favoring statutes that would withdraw that restriction. The company that was particularly the spur to this was Tesla. Right. But Tesla is the camel's nose under the tent. The question is whether or not, as in other industries, the interchange of manufacturers and customers should be determined based on consumer preferences.
So generally, new business models that are threatening to existing business models within some geographic or business group of organizations are always somewhat resisted. But in New Jersey, you saw someone actually create a law around that with a business model that isn't really the government's business to judge upon. I guess that's what
Well, what you see sometimes is that the regulations already exist and they are a bar, or sometimes new regulations are being introduced that would create a bar.
So it actually inhibits innovation and limits competition and kind of reinforces the status quo.
Absolutely, and that would be our concern. And we've seen that pattern repeat in many healthcare fields, in auto distribution, in the taxi industry right now. What we see is heavily regulated incumbents actually using those regulations to impair innovation from new business models and new products and services.
Thank you very much.
Thank you.
Yield back.
Thank you. Thank you for being here today. Mr. Gabel, several states have already begun to offer better reciprocity between their licensing regulations to enable workers to start working immediately following a move to a new state. This is especially beneficial for military families. Besides offering portability to increase workers' mobility across state lines, what else can be done to rein in licensing laws?
Congresswoman, I think that we have actually commented in a number of our comments that these particular issues facing military families are significant, but they are an example of a broader problem. And I think reciprocity laws and portability laws can go a long way towards reducing barriers that impede the mobility of the workforce and the ability to move to where the jobs are. So I would applaud that as a general matter personally and think that that's something worth considering in a variety of contexts.
Under antitrust law, the courts have hesitated to rule on cases involving a state licensing board because of the state immunity doctrine. But one recent case suggests this hands-off approach may be changing even when a state board is involved. Can you give a brief overview of this state immunity doctrine and how limiting, not eliminating, the state's immunity could serve some purpose?
Sure. With one caveat, as I indicated, we do have a case pending before the Supreme Court, and I want to be cautious about commenting on that case in particular. But the broad framework, I think, is a very important one that's been developed over the Supreme Court, by the Supreme Court over a number of decades to try and strike a reasonable balance between the state's sovereignty and autonomy and the national policy that favors competition. And the state action doctrine is an attempt to implement that balance. And I think that it has sought to do that by recognizing that states, when acting as themselves, as sovereigns, should have that kind of ability to be exempt from federal antitrust laws. The more troubling issues come up when they delegate authority to private parties. And that is the issue squarely before the Supreme Court in North Carolina Dental, is the degree to which private parties acting with an imprimatur of government regulation should be permitted to go forth without any deterrent from the federal antitrust laws.
Thank you. Is there a role for the FTC in creating guidance or providing tools on best practices for state occupational licensing board to improve their transparency, uniformity, and clarity of information they provide the public?
Yes, and I think we try to do that very much so in our advocacy program. We are consistent in the framework that we try to use, and I've outlined it in our testimony today, and that is the framework that we urge state regulators and legislators to consider as well, to always take into account the competition consequences of any restrictions that they place, including the fact of licensing any new occupation.
Thank you.
Thank you.
Mr. Collins.
Thank you, Mr. Chairman. You mentioned the taxi issue. Now, New York State, up where I live in Buffalo, we just recently have someone like Uber. It's called Lyft. And they've opened up or attempted to open up service in New York City, Rochester, Buffalo. And they were recently, there was a lawsuit brought, I'm not sure exactly who brought it, but obviously the taxi companies, unions, and so forth. Interestingly, the court ruled that they could not operate in New York City, but in fact could operate in Rochester and Buffalo. And I think the issue gets down to obviously taxi cabs and unions would view them unlicensed, unsafe, and so forth. And I think all of us agree we need regulations to make sure the public's safe, they're insured, people know who they are, and all that goes with public safety, which I think can be handled outside of some of the issues the taxi cabs are bringing up, the cost of a medallion and so forth and so on. I'm just kind of curious, because it's the forefront right now of regulations trying to stifle innovation, what you see going on in things like Uber, Lyft, and so forth.
I think you're right, Congressman, very much so right, that this is just the tip of the iceberg. This is a part of a new and expanding part of the economy. Smartphones have triggered an extraordinary amount of innovation and development through applications that are platforms that allow people to communicate with each other in new ways. And these transportation applications are an expression of that. And I would also agree that finding the right balance in terms of regulation and allowing the free market to innovate is a critical question in this area. We have submitted 4 comments in the last year and a half, one in Colorado, one in Anchorage, Alaska, one in Chicago, and one in the 4th place that I'm not remembering right now. But we've done 4 of those to try and lay out what we think is an appropriate framework for evaluating how regulators should go about adapting to new innovation, permitting it, encouraging it, and facilitating it, while articulating and accounting for any appropriate consumer safety concerns. One concrete example comes to mind. In Chicago, we commented on ride-sharing regulation that was proposed, and the initial proposal required 3 times the level of insurance for an individual person using their car through a ride-sharing app as compared to a taxi. Obviously, that would impose greater costs on the ride-sharing, and our question was why? What's the justification? Is there any evidence to support an increased concern about safety when individuals are using their cars? If there is, well, there may be a basis for regulation, but if there isn't, then you're merely erecting a barrier to competition that may not be justified.
Now, do you see any nexus at all for the FTC on interstate commerce, where you do certainly have the potential in 2 cities in 2 different states where someone might be using a ride-share service to cross a state line that might give you a nexus to some action different than somebody just running around the city of Buffalo?
Mm-hmm. To go back to my last question, I can't believe I forgot the 4th one was the District of Columbia. So let me just get that out and clear. I think that clearly there is national level competition going on in this industry, but historically the regulation was very local. And that alone has created some of the tension. You have new national competitors coming in, and they are facing regulations. As you mentioned, in New York it could be okay in one city and not okay in another city. That's because the legacy regulations are very local. They can be citywide. In some jurisdictions, California and Colorado are examples. There's some statewide regulation. So that makes it quite complicated for an innovator to come in and try to compete in multiple jurisdictions. They have to understand and adapt to the regulations in multiple jurisdictions. That alone increases the cost of entry.
Yeah. Thank you very much. I think that's all I have. Yield back, Mr. Chairman.
Mr. Schrader?
Thank you, Mr. Chairman. I guess I'm wondering why we're having the hearing a little bit. I'm sure everyone that'll come out as we go forward, I guess. But it's my understanding, as a past life being in the Oregon State Legislature, that occupational licensing was a state area of expertise, not federal government. Is that still accurate?
For the most part, it is, yes.
Okay. So I hope there's no inference that we want the federal government to take an increasing role in occupational licensing. Do you feel that's your province to take on the occupational licensing that has been up to the states, been a states' rights issue for a while?
So I would separate my response into 2 buckets. On the advocacy front, typically what we are doing is commending 2 state regulators and 2 state legislators, not questioning their authority, but trying to introduce a competition perspective to their thought process. on the enforcement side, I think we do recognize that many of these professions have a significant impact on interstate commerce, and that goes back to the prior question. And when they do have a significant impact on interstate commerce and it involves conduct that's anti-competitive, it does fall within the jurisdiction of the federal antitrust laws. But honestly, we have used that in a very measured way. Those cases are few and far between, and we try to target them on some of the worst conduct that we find.
I would hope so, because that sort of argument could be made for federal intervention and everything, all state, local ordinances, that type of rationale. I appreciate the measured approach that you guys are using here. You talked about the role of the FTC. I think that's fine. The comment had come up, and you had agreed that it should be the consumers are the most important piece of this, and they're the best judge of whether or not the licensure is working. I guess I had argued that would depend. There are a lot of professions that I think are pretty complicated. The consumer has an unrealistic expectation, the medical field in particular, of what medical anesthesiologists, cardiologists can and cannot do. Lawsuits abound based on mythology of accurateness and invincibility of medical technology or medical approaches. So to me, it seems like there's an opportunity for professions to self-regulate, and the ultimate arbiter is not just the customer, but your state legislature, your state courts. There's really, those folks can probably adjudicate these issues as well or better, having that local perspective and seeing what's actually going on, than we at the federal government. Wouldn't you agree?
I would, and I think that the point you make is a very important one, which is that in the economists would call it, in situations that involve information asymmetries, which just means that we as consumers don't really know that much how to judge the quality of certain things that happen, especially health care. In situations like that, that is a classic justification for some degree of regulation. In pricing contexts, even some of them in the taxi area, you wouldn't want to get into a cab not knowing what the rate is going to be that you would be charged. So we have argued that although jurisdictions should be flexible in allowing new payment models, it is appropriate to think about disclosures to make sure that consumers understand what they are agreeing to, whether it's through an app or getting into a taxi. So I think, yes, across a broad range of areas, that sort of problem with information is a traditional justification for some degree of regulation. I think what we would argue is try to look for the least restrictive kind of regulation possible to permit the free market to operate.
Yeah, and I would agree. I remember as a budgeteer in the Oregon State Legislature, there were certain boards that seemed to be building little protective fiefdoms where the requirements only would benefit a select few that would get the good contracts, and other very well qualified accountants, surveyors, engineers would be unable to apply. But again, I think that's where the state legislature, my Ways and Means group, my budget group, were able to discern that, call the group to the table and have a discussion, and oftentimes we were able to get them to change their rules and regulations. So.
And we work cooperatively with state antitrust enforcers in many instances. When we see problematic legislation, regulation, or conduct level, we often work together with the state enforcers.
So your role is, it sounds like the best role, from my perspective, that you would play is advisory to the states, the legislatures, and the local boards to make sure they're doing things the right way and without restricting competition.
Absolutely, and that's the core of our advocacy program, is about trying to encourage people to take a competition perspective, and we act as competition advisors in that role.
All right, very good. Thank you. I yield back, Mr. Chairman.
Mr. Luke DeMar.
Thank you, Mr. Chairman. Mr. Gavel, I certainly I'd like to focus on the enforcement part of what you've been talking about here. I think it can be a barrier to entrepreneurship if it's not done correctly, and that concerns me. While I support the enforcement of the laws and you're pursuing of bad actors, I have some concerns. Recently the Government Committee on Oversight and Reform did a study and got a hold of a lot of the internal memos of the Department of Justice with regards to Operation Choke Point. And you're mentioned prominently in there in a couple different spots. And I want to talk about that a little bit with regards to, number one, have you or your office had any communications with DOJ with regards to payment processors? an
We have,
operation
we
choke
have
point?
not we have not been involved in that matter at all in the Office of Policy Planning.
Has the Federal Trade Commission been working with DOJ?
I'm honestly not familiar with what might have been going on or coordination between the agencies. It's not a matter that I've had any personal knowledge of.
Well, on page 12 of a memo from the Deputy Assistant Attorney General, it says here that they are working with the FTC through information gleaned through FTC's many actions, and as a result, you've even assigned somebody who your principal payment processor expert to work with them.
Congressman, that may be true, but again, I just don't have any personal knowledge of it. It wasn't my office that was involved in that matter.
Well, you just said that you're part of the enforcement of making sure this all works.
No, the FTC has an enforcement arm. Actually, my office takes principal responsibility for initiating advocacies. We typically do not get directly involved in very much enforcement. On occasion, we do advise enforcers in terms of the competition theory, but on this particular matter, we had no role that I know of.
I mean, that your division did not have. FTC may have had.
I cannot speak for the entire FTC, but my office didn't have any involvement in that matter.
Okay, because I'm very concerned because I think that it appears that with your cooperation, they are going beyond just enforcement. It appears that they're going on a witch hunt to try and do away with entire industries versus just the bad actors within that industry. And they do that by choking off financial services. And apparently your agency has a lot of history, apparently, with payment processors. Is that correct?
As far as I know, we have done work with payment processors. Again, it hasn't been me or my office.
Okay. How do you interact then with other federal agencies in your position?
In my position, yes. In a number of ways. As part of our advocacy program, sometimes we will engage in, frequently we will engage in what we call informal advocacy, where we confer with sister federal agencies about competition issues. Other agencies, for example, that are considering regulations that may have an impact on competition. They may invite public comments, or they may invite our advice informally to talk about the competition consequences. So that's a kind of work that my office would do. That's agency to agency.
You don't see that the competition issue here with regards to other activities within an industry and the payment processing connection between those? Have you ever heard of Operation Choke Point?
I actually had not followed it, and like I said, I have not worked directly on it in my role as Director of the Office of Policy Planning.
Well, it certainly is kind of concerning to me that your agency, which is part of it, you said, is enforcement of,
yes,
and you in your statement here you talk about it. Yet you have no recollection or awareness of the department's interaction with an enforcement agency. I mean, how does that work?
It would not be unusual, Congressman, that different parts of our agency are working with each other and with other agencies, and we just wouldn't be involved in it. For example,
Right
as you
hand
know,
never knows what the left hand's doing?
I wouldn't describe it that way. I would say that we're working on different projects, and not every one of us is engaged with.
I would describe it that way, because you're all within the same agency, are you not?
But none of us are engaged.
Part of your agencies is enforcement as well.
But I wouldn't
But
typically.
you have no concern, no knowledge of the enforcement part of your agency.
I don't think that fairly characterizes what I said. I said I had no knowledge of this particular activity. I think I did say I do have knowledge of some enforcement options and some enforcement actions when I'm consulted and when my office is consulted. We had no role to play in this matter, so I really don't have any knowledge about it.
That's a head scratcher. I yield back. Thank you, Mr.
Director Gavel, in your written testimony, you provided a framework with analyzing licensing requirements. Can you walk us through a couple of examples, one where it would be deemed appropriate for that licensing and one where it would impede competition?
Sure.
Just as examples.
So we recently issued a policy paper on the regulation of advanced practice registered nurses. APRNs are sometimes described as a mid-level professional, more advanced training than a registered nurse, but not the same training as a physician. And in many states, we have seen regulations that would mandate by law that such APRNs can only function under the direct supervision of a physician. Even though their training would allow them to do certain things independently. And so in our policy paper, we question whether these sorts of restrictions can really be justified. And one way to think about it is a mismatch. There clearly is some concern about public safety, but when we surveyed the evidence on public safety, there was a lot of evidence to support the ability of APRNs to do certain things independently and to practice independently. And in a time where access to health care is especially important, APRNs may provide a less expensive and more accessible kind of health care. So our policy paper tries to collect that evidence and sets out the case for why those sorts of regulations may not be justified. And we ask states to consider. And we filed a number of comments, and a number of states actually, consistent with our comments, have been abandoning those very strict supervision requirements, and we've been pleased to see that development. Another one that was actually just in the news this week, the Washington Post had an editorial yesterday about dental therapists. And dental therapists, in some sense, is an analog to APRNs. It's a mid-level professional, more skilled than a dental hygienist, more education and training than a dental hygienist, but not quite a dentist. But in areas where there is shortage of dental care, dental therapists may be a new and emerging model that would allow for greater access and lower cost dental care. And we filed a comment with the Commission on Dental Accreditation, which is the accrediting body of the American Dental Association, urging them in a similar way to avoid using the accreditation process to mandate supervision by dentists and not allow these dental therapists to autonomously provide certain basic services. So those are two recent examples where we felt like the regulation was a mismatch. It was excessive and inappropriate. In the taxi cases, to give you an example where we do think some regulation might be appropriate, the issue has been whether the regulation is greater than necessary to meet the needs of consumers. Certainly we all care about safety and quality, but as I mentioned earlier, an example would be insurance. Would we concede that some insurance requirements, some inspection requirement might be appropriate? Yes. But when we see disparate requirements that would create a competitive disadvantage, we would question those and ask whether they really have some factual basis and can be justified.
Well, I want to thank you for testifying today and shedding some light on the role that obviously the FTC plays in protecting competition and ensuring that entrepreneurs have opportunities to enter various occupations. We very much appreciate you coming in. And with that, I would ask unanimous consent that members have 5 legislative days to submit statements and supporting materials for the record without objection. That is so ordered. And with that, the hearing is adjourned. Thank you.
Thank you, Congressman.